In 2013, I advised the Guardian in relation to its Snowden disclosures about GCHQ. I also do many of the source disclosure cases involving journalists in this country in the domestic courts. Earlier this year, that is me and a group of other lawyers, having put two and two together, the Snowden disclosures about mass data harvesting and our concerns about protection of journalistic sources and confidential journalistic material, decided to bring a slightly different case to Strasbourg post-Snowden to the ones that had been filed already. It's known as the Bureau of Investigative Journalism versus the UK. The Bureau is a sister organization of CIJ. There are lots of links between the two, and it's an online investigative journalism outlet. It also does investigations and produces copy which is published and broadcast by other major news organizations. A lot of its work involves what are called under REPA external communications, that is telecommunications, particularly over the internet by way of email with people in other countries. And a lot of its work involves the security state and investigations into what the British and American governments are doing in relation to things like the use of drones, removal of nationality, and creation of statelessness for British citizens. So it's a global investigatory organization, and it is a perfect litigant for the case that we decided to bring against the United Kingdom. The premise for the application is straightforward. Vast quantities of data are being intercepted by GCHQ. This is where we put two together. It must include, must it not, a lot of confidential journalistic material, as well as citizens' material protected by privacy rights, including material tending to identify confidential journalistic sources. And certainly a lot of the external communications of BIJ would fall into those categories. So what is difference between Article 8, the European Privacy Protection, and Article 10, the Freedom of Expression provision that protects journalistic activity, is that there is a stronger and a higher protection for confidential journalistic material, and particularly that material that tends to identify confidential journalistic sources. There isn't the time to go into the detail of the enhanced protection that this material gets from interference by the state under Article 10, but essentially the state is not allowed to access that material from a journalist for the purposes of a criminal investigation or for any other reason, unless a judge or a quasi-judicial body has made an assessment on the facts of the particular case that the constant public interest in protecting journalistic sources is overridden by a higher and a more important public interest, and that all other means of obtaining the information the state wants to find have been tried and exhausted. So it's quite an exacting test, but critically and uniquely it involves the facts being placed properly and honestly before a judge to decide whether access can be obtained. As with Article 8, the way the provision works is the state must be able to offer guarantees to citizens, particularly journalists, that those principles will be respected within its domestic law system in all instances. So plainly that was not happening in relation to journalistic material which is being accessed through PRISM and Tempora and, for all we know, other programs. Nobody knows how that material, telecommunications data and content, is being analyzed by GCHQ and its partners and used. There is nothing in the domestic legislation, the Regulation of Investigatory Powers Act, or in any of the codes of practice under it, which give any answer at all to that question. How is it processed, used, and so on and so forth. But we do know in most instances there is no judge involved. And in relation to Section 8, there is executive authorization, but not authorization by a judge. So the application was filed in September. We've had enormous and very welcome support from The Guardian, the NEJ, the International Federation of Journalists, the Media Lawyers Organization in this country, the MLA and its American equivalent, and many other NGOs, for the case being given priority and being brought together with existing cases that went straight to Strasbourg, such as one brought by Big Brother raising the Article 8 issues. We bypassed the Investigatory Powers Tribunal and went straight to Strasbourg because the IPT, which is a strange adjudicatory body which doesn't respect fair trial guarantees and Article 6 of the Convention, is largely secretive and tends to find for the state, cannot, as a matter of statutory law in this country, offer a declaration of incompatibility, which is essentially what we're looking for in our application to Strasbourg. We want the European Court of Human Rights to say the REPA regime, the Regulation of Investigatory Powers regime, and the way it's implemented in practice is incompatible with these guarantees that are given to journalists under Article 10. And you can't get a declaration of incompatibility from the IPT. In addition, as Carly has explained, there's no disclosure or anything like that. You don't find out in any detail or the necessary detail to have a fair hearing what the position is of the state agencies as to how they are carrying out their work and how they're using these powers. There's a one-sided disclosure from them to the tribunal, but you sit out in the cold as the applicant to the tribunal and don't really find out about that stuff. And that's all regarded as okay in the IPT, but such cases as there have been in Strasbourg in this area suggest that the judges in Strasbourg will take a rather more dim view of the UK answering an application under Article 10 without putting at least some of its cards face up on the table. So we're waiting to hear from the court, and our aim is to force change in the law here, in the statutory law of the sort that Ben has spoken about, black letter law, primary legislation protecting the journalistic rights against this sort of state encroachment. And also the ruling would represent a set of principles or standards to be applied across Europe. So that was filed in September. At around the same time, some of you may know, two examples emerged in this country of the police using covert surveillance powers under REPA to identify confidential journalistic sources. The procedure under which they did it involved accessing telecommunications data, going to phone companies and getting telephone records of journalists and media organizations. And that procedure not only does not involve a judge, but allows the police to go to an officer in the same police force that's conducting the investigation, provided that officer is of the rank of superintendent or above, and provided that officer is not actually involved in the investigation in question, and get an authority which is then sent to the telecommunications company, which requires it as a matter of law to hand over all of the phone data sought. And both of these examples emerged at roughly the same time. Both involved former cabinet ministers and police investigations relating to former cabinet ministers. And both involved importantly, the phone records of journalists and newsrooms at mass circulation newspapers, tabloid newspapers, being accessed. And the effect of that was to create rather more of a public debate around the issue of state use of these REPA powers to identify journalistic sources than we had managed to generate through our application to Strasbourg the month before. When the domestic newspaper industry takes up a cause that affects its own like this, you can generate instant political traction in a way that mere NGOs and human rights lawyers sometimes fail to do under their own steam. And I'm not knocking it. It's very important and very germane to the topic we're discussing, which is fighting for new laws. Because to get new laws, we need to get the politicians on side. So this created a quite different domestic political issue for the government. It wasn't terrorism. There was no lurking terrorism justification, as there is with PRISM and Tempora. These were politically motivated investigations, and the use of the powers was prompted by heavy political pressure, let's put it that way, in those two cases. So that has prompted in this country, in relation to the use of these covert REPA powers against journalists, a report of the reviewer of government terrorism legislation, David Anderson QC, which is being filed this month with the government, with the Prime Minister. The Interception of Communications Commissioner is investigating the use of these REPA powers against journalists and will also report to the Prime Minister. And as you probably saw yesterday, the Home Affairs Select Committee in the House of Commons took evidence on this and promulgated a report, as I say, yesterday on Saturday, indicating that the use of these powers by the police against journalists was unjustifiable and was opaque and not properly recorded, and they couldn't gather evidence about how these powers were being used. So the key problem, as foreshadowed by Ben's comments, is that in our country, as in many others, there is no black letter law protection in primary legislation for journalists in relation to the use of these covert surveillance powers. The government's response in the current political debate generated by those two cases, Theresa May's response, the Home Secretary, has been to say, well, we'll rewrite codes of practice under REPA to change the way the police operate in practice. But those will not suffice, those sorts of changes. My experience of the police in this area is that, having done many of these cases and having debated with them in public, is that deep down they feel that the end justifies the means, and they're not terribly bothered about journalistic rights, Strasbourg rights, Article 10, the need to go before a judge. They have realized in recent years that journalists hold large amounts of digital data which are potentially very valuable to ongoing police investigations in a lot of different areas, and getting access to them covertly through these very loose procedures, particularly loose in relation to external communications, which, as Carly said, were traditionally regarded as communications outside of the country and back, but in practice, it's just emails going through routers and servers in other countries. Their view is that easy access to that material is very helpful, and they're justified in using it in the fight against crime, and not necessarily even serious crime. It's just a short hop to an end result for them. It's lazy policing. It's an easy way of doing their job, but if it rides roughshod over rights of journalists, well, hey, who cares about that, provided they get the job done? And that, deep down, is their attitude, I'm afraid. And that will not be given up easily. They are a serious lobby in government decision-making. And that is where the fight is going to have to take place in this country to change laws. and practices as well, of course, but laws are very important. So my position essentially is that what is needed is a shield law, a freestanding primary piece of legislation, which is a proper shield law for journalists in this country in relation to this sort of material. That judges and police officers can't say, whoops, I missed it, I didn't know about it, or I forgot about it, because it has quasi-constitutional status and has a memorable name and lots of important principles stated at the start of it, and that they will have to confront it and apply it if they want to use these powers against journalists. It is also very important that, looking at practice rather than black-letter law, that government in all its forms prevails upon the police and security services to keep proper records of how they're using these powers against journalists. Their prevalent response in the current debate has been to say, well, we just don't know. We don't know, and we don't go terribly deeply into whether the person's a journalist or whether the material might identify a confidential journalistic source, because that's all a bit complicated and sophisticated for us. So we can't pull up the information. If you want to know how many hundreds or thousands of journalists have had their material accessed in this way, we simply can't tell you. And that is not good enough in a democracy with an issue as important as this. I do a lot of work in Europe and Eastern Europe for the Council of Europe and the EU with journalists. I'll just say this finally before I finish. And I was on an EU mission in Macedonia in October, which is a country that has poor media, not a terribly free and active media, and where life is very difficult for journalists. And I met a group of journalists there, and I said, well, what's the state of play in your domestic law and practice in relation to protection of confidential journalistic sources? And they looked at me and said, we don't have any confidential journalistic sources in this country anymore, because the ones that were willing to whistleblow in government or in big business left and no longer have access to the information, and the ones that are still there are just too scared because they know they'll be found out if they blow the whistle. And so we don't have any stories. We don't have any public interest stories of any great value. And that is an extreme version of what can happen in any country. And it is vital that we use laws and good practices to protect these journalistic rights. Otherwise, we will begin sliding towards that state of affairs in our country as well. Thank you very much.